Good morning, everybody. We'll start just as people sit down. Let the last bit people get the coffee. If you want more coffee, get it now. Let me welcome everybody to New York Law School. I'm Ross Sandler, Professor of Law and Director of the Center for New York City Law. And we welcome you to the second breakfast on police issues, police integrity issues. The first one, we discussed the Knapp Commission. Mike Armstrong was here. And as many of you may know, or perhaps don't know, that these breakfasts are videotaped and webcast on the center's website. And then they're cataloged there, so you can go back and look at any over the last almost 10 years of the breakfast speakers. So if you missed seeing Mike Armstrong, you can see what he had to say about the Knapp Commission. Today we're moving forward to the period of the Mollen Commission and what came after that. And we have two speakers, which is unusual for us, but we thought that it would be good for on this topic to have two, both about the Mollen Commission and what it did, and then the follow-up with the Commission to combat police corruption. The two speakers are good friends, but they also have resumes of things they've done as lawyers that are really extraordinary. Harold Baer, Jr. is a senior federal district judge in the Southern District. Before that had been an elected Supreme Court justice, president of the county lawyers, chief of the criminal division of the Southern District, and an assistant there. And I guess to the point, and this is really an important bit of little history here, that he was the executive director of the Civilian Complaint Review Board under Mayor Lindsay, which was in many ways the genesis of a lot of the thinking about police review boards of police. Mayor Lindsay, of course, created it after his election in 1965. The police union were able to overturn it through a referendum. Harold lived through that and knows a great deal about that experience. And then Mayor Dinkins appointed him to what was then the Mollen Commission, named for Milton Mollen, and they reported in 1994. The second speaker is Richard Davis, formerly a partner at Weil Gotshal, but his experience also is in the Southern District, and then as a Watergate prosecutor, one of those very important young prosecutors who led those prosecutions following the Watergate. He was Assistant Secretary of the Treasury, where he supervised the Secret Service, Customs Service, and others important parts of the government. And then as Harold, the two of them have done so much on the public side. Richard Davis is currently the chair of the Legal Aid Society, has been chair of sports facilities on Rikers Island, active on the Hudson River Park issues, and has really distinguished himself on both the public and private side. He was appointed to chair the Commission to Combat Police Corruption, and in that capacity wrote and really set the tone for that institution and wrote very substantial reports, and he's going to speak about the follow-up of the Mollen Commission and what happened after that. So I'm going to first bring Harold Baer to the podium and welcome him, and then Richard Davis will speak. So we welcome Judge Baer.
Thank you for that. Thank you for that introduction. I hardly knew where to start here because the Mollen Commission is now close to 20 years in the past. And looking back, you want to look back, having been a member, and think about all the wonderful accomplishments that Ed and Mike Armstrong and the Knapp Commission accomplished. But I'm really unclear that there was a great deal of constant and continuing improvement. Mollen Commission began in '92. Basically, I'm sorry, yeah, I guess. And basically there were 5 of us and a fairly significant staff of private investigators and people who one or another of the commissioners had known for a long time and trusted. And trust was and is a major ingredient of this kind of activity. And we spent a long time putting together investigations and eventually making it clear that there were significant differences between what had occurred in the Knapp Commission and what was occurring 20 years later in the Mollen Commission. As you know, for some good or bad reason, every 20 years from the early 1920s, there had been a new commission to investigate police corruption. And obviously the need for it was because the earlier commissions really had not made any gigantic improvement. And of course we believed we would. The lawyers that we hired were all very bright and all very enthusiastic. And the original investigative work was just so you understand what we were doing, came about from a variety of tips that said that, this is an oversimplification, but that said in substance, there are cops who are beating up people selling drugs and then taking their money. And of course, that was a pretty good deal for the cops when it was effective because the drug dealers were not anxious and likely to go to the police to complain that their drugs had been stolen or their money. And we were able to find 1 or 2 such instances, and we were pretty clear from what we did find, it was pretty clear that there was much more of that going on. But basically, if I had to put our accomplishments on the corruption front in one area, that would be the area. And it was a somewhat different area, and as the report, which is too big, but in any event, the report is interesting from that standpoint. It makes it quite clear that it was very different in the Mollen versus Knapp day, and that it had been a somewhat lower level, less violent operation during the Knapp Commission days, and that in the 90s it was a lot more violent. And I think probably that was a finding that nobody has argued with. What really made the difference, I think, in our report, and I guess probably does in many reports, is that the recommendations, Mollen is a pretty smart fellow. I don't know if you know him, but he, unlike a lot of us who do things without too much forethought, he actually went to Kelly and said, listen, we have a variety of recommendations here, and we really would like the police department to adopt them, A, because they're sanguine and valuable and will make a better department for you, but B, because we don't want to come out and the next day see the paper, see that you're blasting the Mollen Commission for what it had reported. And so things went along fairly well on that level. I'll just read you a couple of the things that we had done that seemed to me would be carried on and would be valuable, and to which the police commissioner was agreeable. Internal investigations and intelligence. Internal Affairs Division, as you know, that's a group that looks for corruption and wrongdoing amongst its own people. Not an easy job, ever. Leading into the 90s, IAD virtually abandoned its primary function over the past years to investigate serious, complex, and sensitive corruption cases, to oversee, assist, and ensure the quality of command accountability and the conduct analysis on corruption trends. And then in terms of recruitment and screening, those procedures were, I didn't believe this when I actually heard it in '93, I guess, and that may be because I may have had too much education. But the way it worked in the police department in the early '90s, recruitment and screening procedures were overly lax and let individuals become cops who should never have become cops. For example, 24% of dismissed or suspended officers had a criminal record. Additionally, background tests were often hastily done, and the department did not conduct random drug tests of applicants, despite the fact that 40% of dismissals in the early 90s were drug-related. And that, to a degree, lopped in and over to training. I'm sure it's very exciting for you to listen to me read this, but I'm just going to read you one more recommendation because it's sort of on the same line. The department's integrity training did little to promote integrity, and because it was taught by IAD, it sent the wrong message that integrity was not a responsibility of the department. What little training was available was outdated, focused on corruption hazards like gambling pads, and that no longer exist. So the department in the early 90s was living in the 70s with the kinds of problems that albeit the kinds of problems had changed. And I think as we went through the kinds of changes we thought might be helpful, one of them was an investigation and a commission that would be there at all times, somewhat similar to what Rich Davis did, but he makes it clear that it was very different. But the concept was the same. It was to look and maintain what it was that the police department had done that could be corrected. And unfortunately, on the corruption side, there may have been some changes, but in terms of the training and what at least one would expect the training to produce, I'm afraid that at least from where I sit today, this has really not worked very well at all. So I put together a chart where I only took the 2010 and 2011 cases that are brought under Section 1983. As most of you know, that's essentially police behavior that injures individuals. Not put perfectly well, but that's essentially what the Section 1983 does. And I looked at the ones that were really egregious, or at least in my view, what the police had done were egregious. And one way I figured that out was to see how much money the city paid to settle the case, which is not a bad way in my experience. I'm not going to read you all of these, but I would, if there's one short one. Anyway, in 2010 and 11, there were over a dozen cases in which the city of New York paid somewhere between $35,000 and $140,000 just to settle the case. The $30,000 mark I used is a really high one. There are hundreds of cases that come before me for settlement for $5,000 and for $7,500, and they all include or essentially are related to what we could, I guess, gratuitously call bad acts of policemen. So it is, that kind of problem is sort of widespread. Let me read you one that looks short. I haven't read these for a couple of days. This is an 11 case. Plaintiff filed a cause of action against the city regarding the following sequence. On June 18th, plaintiff, a social service worker, entered a residential premises in Harlem to meet a client regarding a vocational program. Police barged into the residence, placed, of course you have to understand this does not come from the police department. Plaintiff, a social service worker, entered the residential premises in Harlem to meet with a client regarding a vocational program. Police barged into the residence, placed uncomfortably tight handcuffs on plaintiff, and arrested her for possession of narcotics. At no time was plaintiff ever in possession of narcotics, nor had she committed a crime of violence. Police had a search warrant for the premises, but plaintiff was not the target of the warrant. Plaintiff was brought to the precinct and charged allegedly in an attempt for several police officers to earn overtime and boost arrest numbers. Plaintiff's complaint included the following claims: false arrest, unreasonable force, fabrication of evidence, and denial of a fair trial, malicious prosecution. Monell claims that is a sort of claim that rarely survives, in which a policy is proven, a policy that is against the law is proven as something the city engages in. In any event, I just give you that as a short version of what is currently the kind of different program, or different, I think, corrupt activity on the part of police, going from the 70s to the 90s to 2012. It doesn't mean that there isn't any corruption in terms of what the Mollen Commission found, or the Knapp Commission. It just means, and I wanted to be sure to leave you with a thought, it just means that there is a new concept of wrongdoing afoot, and I guess probably if you read the newspapers, you know that too. But I was quite aghast to see the number of 1983 cases that the city, who I assume looks at these from a standpoint of trying to win them, or at least find the best way that they could resolve them. I assume that they're not, the précis that I read come from the city and the Corporation Council for the most part, and I assume that they come reasonably neutral. And of course, one has to realize that it all goes back to training. I mean, it's not hard to realize that if these police were provided with the kind of training that the Mollen Commission had advocated, and which the police department indicated they were going to buy into, it is to be hoped that this kind of wrongdoing, which from the numbers seem rampant to me, might at least be reduced. So I'm not here today to tell you so much about the Mollen Commission, which is now, 20 or close to 20 years old, but to bring you up to where we are today, and Rick Davis is going to fill you in. Thank you very much. Stay up there?
Thank you, Judge. I'll actually fill you in for some years, but my tenure actually ended in 2002. But as you heard, one of the key recommendations of the Mollen Commission was to create an ongoing permanent commission in recognition of that 20-year cycle. They said to break that, have something there all the time that's putting the IAB under pressure to do its job and to do a good job. Now, it recommended that the commission be an auditor monitor and also have independent investigative authority to investigate allegations of corruption as part of its role. So what happened? Well, as some of you who remember history, you'll not be surprised to hear that there was a struggle and fight between the city council and the mayor over exactly what the commission should be. Should it have subpoena power? Should it have investigative power? Who should appoint the members? Should it be the mayor appointing, or should it be the mayor and council member, the speaker, or having a role in the appointment process? When they couldn't agree, the mayor created the commission by executive order. And that commission, is fair to say, it was an auditing, monitoring agency with no meaningful investigative authority. And I'll come back to that a little later as to whether I think that is good or bad. And it had no meaningful, it had a way to get a subpoena, but it was somewhat convoluted in terms of having to go through the Department of Investigations. So that commission was created. I should tell you there was litigation because the council then went ahead to try and create its own commission, which gave it more authority over appointments, and ultimately the court ruled that that could not be done absent a charter amendment. And so the Commission to Combat Police Corruption that was created by the mayor by executive order continues today. So what kind of auditing, monitoring, what does it mean to have and what was the scope of what it was supposed to audit and monitor? Plainly, it was going to look at IAB and oversee IAB, and people, and we had people going to meetings at IAB constantly, and as I'll reference in a second, had specific studies focused on IAB. But its authority was broader than that. Its authority also allowed it to perform studies relate to corruption controls, to prevailing culture within the department that may allow corruption to continue, and the department's efforts to address that culture. So the kind of studies that were done in those first 5 or 6 years were actually somewhat broad. It did pick up on some of the issues that had been raised by the Mollen Commission specifically, because there were issues about something called integrity control officers who worked in the precincts. So it did a study of integrity control officers. It did studies, again, as I said, of how IAB conducted its own interviews, and not surprisingly found that the higher up the person being interviewed was, the less effective the interview turned out to be, the more pro forma it was. It looked at hiring, and it did look, as the judge referred to one of the issues, as background investigations. But one of the things it spent a lot of time on was looking at the disciplinary system. It looked at how the department prosecuted or dealt with officers found to have lied, off-duty misconduct, problems of alcohol in terms of the department. And it looked at how the police prosecution function worked, and more broadly, it looked outside of IAB in terms of if you went to the precincts, what kind of mechanisms were in existence at the precinct level to sort of proactively address corruption issues. So that was sort of, as I say, fairly broad, and a number of reports were done. But this, again, this is a mayoral commission. It doesn't have real subpoena power. And I think it's fair to say, based on my experience in early 2002, is that the incumbent commissioner had a narrower view, the new commissioner had a narrower view of what its authority should be, and felt that it should really focus on just overseeing IAB. And I think, if you look at the public record and some of the council hearings, you'll see that the focus has been narrower and the reports have been fewer, in the last 8 or 9 years. Now, in terms of, an ongoing commission, sort of a couple of observations in terms of, conducting itself. I always like to say, and this is not to suggest that the Knapp Commission and the Mollen Commission were not constructive, but it's important that it be a constructive pain in the you-know-where. If it's not constructive, it's not going to actually be able to generate change. If it's viewed as just being, issuing a report, trying to catch the department, it really isn't going to, I think, accomplish its core goal, and that is keeping pressure on and generating change. I mean, how did this manifest itself? I think that in terms of the reports, if you look at them, you'll see that the language I felt was clear and direct, but very rarely very inflammatory in terms of its descriptive tone. And similar to what Judge Mollen did, we always would send drafts of the report to the department, just this is the way the controller's office works, get their comments, talk to them about recommendations, and indeed, in doing so, we sometimes were able to actually get quicker change. One of the key examples, and this was one of the earliest reports we did, was the one I referenced on the police department's dealing with officers found to have lied. That report, issued in 1996, found that they were not really being punished very severely. And the commission felt that that's, one, a very bad signal in terms of the so-called blue wall of silence, one. And two, as a practical matter, once an officer is found to have lied, he's going to be very weakened in his ability to be an effective officer. Think of him going, every time he's called upon to testify, the fact that there's either an administrative finding or a judicial finding that he had lied, how that's going to undercut credibility. And I remember, we initially said we wanted a presumption that that officer would be discharged. And we had, a number of meetings before the report was issued. And there was a huge, quote-unquote, compromise. I put huge in quotes because I don't think it was much of a compromise, because it was that the department agreed that it would adopt a policy that said, absent exceptional circumstances, an officer found to have lied would be terminated. But that's just an example, because I remember again, when we were dealing with alcohol issues in the department, sitting down with the then Deputy Commissioner Pat Kelleher and really trying to work through a set of recommendations that would be implemented and make meaningful change. Another thing about an ongoing commission, which I think is useful, is it can go back and look at what has happened to its earlier recommendations. Again, if you look at the issue of this, police found to have lied, I think in the 4 or 5 years that I was there after we issued that recommendation, we went back each year and looked at how the department was doing and published an analysis, a critique, where we agreed and disagreed, and we went back and looked at the background investigations a second time, and I think that's continued. The ability to look back is very important in terms of, I think one of the goals of the Mollen Commission is to make sure the department does not over-relax. One of the issues, that the Mollen Commission did say, as I said before, was that it should be a commission with independent investigative authority, that it should investigate allegations of corruption. Based on my experience, I actually don't agree with that. I think that if you're going to be an auditor monitor, which I think is an important critical role, it's almost inconsistent with having your own investigative authority, because there'll be a concern that you're going to become a rival investigator. What you want to do is be able to get into the bowels of IAB, really see what they're doing, have access to their information. And if they think that you're just going to take that and sort of steal their thunder, or you're going to become the investigator, I think it'll sort of close them off to, I think, the necessary cooperation that you need to be effective. While I disagree with the current commissioner when he referred in recent testimony to the existence of all the DAs and all the people who can investigate corruption as to why you don't need a stronger auditor monitor, I think that is a good argument as to why you really don't need still another entity doing underlying original investigations of corruption. Now, where are we, and what are the things? Because you read the papers over the last 6 months, and you see the range of different issues. I think it is unfortunate that going back now 16 years or 17 years, that there was an inability of the council and the mayor to agree. I think it would be a more credible oversight body if it was created by statute. I think it would be more credible oversight body if it had subpoena authority, because it isn't not necessarily that we didn't get information from the department, but it shouldn't necessarily be in a position where the department can totally control the pace of that. I think that we always want to work with the department, but I think this, to be effective, it would be useful if the entity actually had subpoena power to use, if it needed to get information and felt that the department wasn't adequately cooperating. Like, I think that having an entity, and that had, a little more oomph to it, and perhaps, in reaction to what the judge was saying, what he sees as one of the areas of quote-unquote corruption, where he really sees it, it's not really classic corruption, it's sort of a different form of police misconduct, which it's not clear comes even within the jurisdiction of the current commission, in terms of which is supposed to focus on more traditional corruption. I think it would be useful to have an entity that had maybe that broader authority. And even from the department's perspective, I think it could be an important escape valve for people who have complaints, for people who are concerned. I mean, there's the litigation that was filed in the Bronx over quotas, over the claim by the officer that there were impermissible quotas being put on. I would suggest that if you had an entity which at least the officers and the public recognized that was more visible and had clearer authority and was created by statute, that person may well have been willing to go to that entity as opposed to file a lawsuit. So I think it could, having an entity that has, more authority and more power than the existing entity would be useful, not only in terms of actually doing the job, but in actually in giving an escape valve for officers who feel that something wrong is going on, that they have a place to go to if they're not comfortable going to IAB. And I know in the first, years, we did get officers come, but as time goes on, and the perception would be that, it's not a commission that has a lot of authority, I think officers would less and less are willing to, use that as the escape valve. So those are just some thoughts. I know Ross wanted to allow time for questions for the judge and myself, and that's it.
We will open up the mic. Where are the mic? There's a microphone there and one here for questions or short comments. I want to say that the next breakfast is April 20th, a Friday, and it'll be Commissioner Richter of Administration for Children's Services, so that'll be on Friday, April 20th. I also want to say that these breakfasts are co-sponsored by Con Edison, Verizon, and the law firm of Greenberg Traurig, and we're very grateful to them. Okay, questions or comments? Yes, should we start?
One comment and inquiry for Mr. Davis. I've been an avid reader since the second annual report that you put out.
Oh, that's amazing.
I've got them all. I just wanted you to know that I found them extremely well written, and anybody that wanted to know about IAB, everything is in here. My question is, one of the summaries you had, summary of reports, March 2000, of former IAB members, you noted an issue that somewhat had bothered me, that the terms are very short. At that time, 2 years, and you recommended going to 3 years, that IAB members rotate in and out. My question to you is, do you have any opinion as to whether there should be the continued rotation of officers in and out, or a possible return to a permanent cadre of IAB?
It's a tension. It's like a lot of tough issues that, you could see the pluses and minuses of both. I think that after the Mollen Commission, to try and improve IAB's operation, there were two things that were done. One was that when officers were being elevated or promoted, and there would be different bureaus were given choices as to, IAB had the first choice to sort of take that person, to try and improve the quality of the people who were in IAB. And second, they went more to these rotations. I think that the theory is that, you will get higher quality, you will get people who are not so inbred within IAB that they don't really know what's going on out there, and less, you versus them. I do think that, making it longer than 2 years would be useful and important. I know a lot of the officers who felt that they were compelled to go to IAB didn't really want to stay, but 2 years, I believe, was short.
Thank you.
Go to the microphone, Claude.
Hi, my name is Jeffrey Rothman. I'm a 1983 practitioner. One of the really unfortunate things that is happening is that the number of 1983 suits that are filed, there is no mechanism within the police department to track any patterns within them or against particular officers or particular practices. So the effect is that the City of New York pays out a significant amount of money, does no investigation at all or tracking as to patterns so that they can stop paying that money out. And it's almost as though it's simply a cost of doing business, that these suits are filed, payments are made, and nothing is done to address the problem. For example, there's a pervasive problem of officers erasing evidence, breaking into phones when people are filming, retaliatory arrests for people filming. People get taken into the precincts. Officers go into the phones and they erase the phones, or they take the phones so that evidence is erased. Just off the top of my head. And there was an op-ed in the New York Times fairly recently by a professor, I think from California, who was pointing out that there is no way, no mechanism at all within the police department for them to keep track of these suits. And so that would be one, I think, essential mechanism that the police department could employ in order to try to limit the number of the 1983 suits and to address the problems underlying them.
Well, I think we sort of morphed into this because obviously it wasn't part of the Mollen Commission or Rich's. But I certainly agree with you. I guess, though, that at least there are plenty of people like yourself who, when you're doing these, have opportunity through discovery to get their personnel files and understand whether or not they had a previous brush with other citizens. But I certainly wouldn't argue with you that I don't know how long it took some poor intern of mine to put together these couple of dozen cases. But there isn't any doubt that it wasn't, she couldn't call up and say, I'd like to know what happened in the 1983 cases you settled in 2009 and 10.
Yeah, the personnel file will not indicate the number of civil lawsuits that are filed naming particular officers as defendants.
It may or may not.
It
And
will not.
the CCRB file certainly also gives you a complaint list. It doesn't do the whole, I'm not arguing with you, it doesn't do the whole thing for you. The question really is, why isn't that something the police department tracks just for its own sake so that it avoids the city spending all its money? I mean, I have no idea what they spend, but in just this very small sample that I made, it was over $250,000 in a year, and 2 years, and it was only with respect to those cases where they paid out a lot of money, or what I thought was a lot of money. I think I told you the floor was $30,000. But as you know, I mean, the case is just for my own information, and you can take the fifth if you'd like. Of the cases you've settled in the last 2 years, have the great majority of them been under $30,000 or over $30,000?
They vary. They're on both sides of that line, certainly. It depends on the damages, and as always, it depends on the strength of the case on liability. But there's been a number of them that are over $30,000.
I mean, going back to my days a generation ago at Treasury, I've always believed it important that law enforcement agencies get feedback when something is found to be wrong. Like, for example, I actually believe it would be useful every time there's a suppression motion granted by a judge, that the information goes back to the department, so we could have information for training, I mean, if for patterns, things that goes wrong. So I know beyond CCRB, which I know you can track per officer, I do think, if they're not doing it now, it would be useful to have more centralized filing, again, for the departments, not only in terms of how it might want to impact a particular officer in terms of if there are a series of number of complaints, but just in terms of how they need to adjust training.
Indeed, and even on a precinct level, if you track, particular types of practices that are complained of in civil lawsuits that all come out of the 46th precinct, and you see that there's a pattern of allegations of illegal strip search in the middle of the street or something to that effect. But I'm taking...
Again, you have to be careful in terms of not taking every allegation as being true, at the same time, being able to, factor in that caveat and make whatever adjustments you think.
My name is Leo Glickman. I'm also a Section 1983 practitioner. And just to add on to what Mr. Rothman was saying, there actually is legislation in the City Council, the Government Operations Committee, that was introduced, I believe, in 2010 and has been stuck there since, to do exactly this, to require Corporation Counsel to produce reports that would show patterns on a precinct level, team level, and individual officer level, so that the public can see it and the department can see it and use it. And I think, for this audience to sort of get behind that would be a great thing for the city, because it'll help move the legislation, because, the wild Section 1983 radical practitioners are not the kind of people that influence the mainstream. So I'd love to see everybody get involved and get behind that bill.
Let me ask a question. Pardon me. In 1965, when Mayor Lindsay created the Civilian Complaint Review Board, the issue that seemed to carry the day was that the police department should should control its own integrity issues, and even the mayor should be out of it. Then the Mollen Commission recommends an independent body, and Mayor Giuliani said that the council shouldn't be a part of this, and he fought litigation, I think three litigations to win that, the principle being that the mayor should control the police department. And so here we are today. Are we in the right place? Would you make changes on how you would structure the external organization that would look into police integrity?
Well, one, as I said before, I think it should be created by statute. I don't think it should be by executive order. Two, the issue of whether, independent of the expression, independent of the department or independent of the mayor. To some extent, I'm okay if it's mayoral appointments. Ultimately, the mayor is going to be accountable. I think it would be probably useful if you had, as to a chair, advise and consent of the council, something to sort of promote the notion that you have somebody of some independence who's chairing that commission. But I do think it should have more authority than the current one has in terms of, as I said before, subpoena authority, and I think it should have clear jurisdiction, and I would extend its jurisdiction more broadly in terms of misconduct and not just focus it on pure classic corruption.
Well, it's interesting. There's now like 40 years since I was the director of the Civilian Complaint Review Board, so you might not all remember exactly how it came about. As Ross mentioned, obviously it was the mayor who put it together, but it originally was called the Independent Police Review Board because it had a majority of civilians on the board, plus a civilian executive director. I've had a lot of jobs in my time. It took less than 8 months before the Police Benevolent Association overturned that concept at the polling places. So by November or December of '68, I guess, there no longer was a civilian aspect to the Complaint Review Board, and they all became police-dominated. I guess dominated means we may have had some. I didn't stay very long after that. But I guess what happened is, or what you would understand just from a psychological standpoint, is that while we were all fearful that as soon as the cops became the majority of the board, that there would be fewer, if any, substantiated complaints. And as it turned out, the reverse was true. There were more substantiated complaints when the cops were in control than when it had been civilian dominated. I think one thing that I've seen in a number of different investigative entities that I've been a part of is something that Rich touched on, and that is, if you don't have subpoena power, it isn't going to work, and you can take that to your grave. It is impossible for several reasons. One is the agency that you're targeting doesn't really have to produce the records that you ask for because there's no subpoena power. And B, if they have to produce the records or conclude that they want to produce the records or want to look like they're producing the records, the problem again is time. These commissions, all of them, Mollen Commission and NAP as well, have a finite life. They don't just go on forever, which is one of the reasons that the Mollen Commission suggested something a little different. And in a couple of commissions this actually happened, and I'm sure all over the country it happens as well. If you don't have subpoena power, the commission will eventually go out of business and you will have accomplished nothing. You won't have the records, and you won't have the opportunity to scream and yell because you tried your best, but indeed nobody had to give you the records, so they didn't give you the records. So there are a lot of problems in connection with having some investigative agency that actually does a job, and you have to be responsive to it.
I mean, even for the ongoing commission, which isn't going to go out of business, I think if you don't have subpoena power, essentially the department will define your jurisdiction as opposed to you defining your jurisdiction, because they just won't give you the documents. Obviously, the mayor can intervene at particular points, but often mayors do not want to intervene and overrule their police commissioners.
Yeah, I'm just wondering, is it possible that there are two...
Microphone? Yeah.
Should I use the mic?
Yeah.
Here, she's bringing it right to you, John.
Yeah.
Okay. What I'm thinking about is whether there are two completely distinct areas that we're talking about. One area being police corruption per se, which is inherently surreptitious, the kind of conduct that made the big headlines during the Knapp Commission with Phillips and the meat eaters and, kind of police being on the payroll of drug dealers and so on, that are classic concealed corrupt activities that require very sophisticated undercover operations, sting operations, working with prosecutors, and so on. Sort of the heart of corruption, as distinguished from a lot of what we've talked about that Judge Baird talked about at the beginning, which is the interface between the police and the public, which is much more transparent, which is the 1983 cases, the brutality cases, the stop and frisk, all of the situations where it's not so much a matter of concealment, but of relating to the public in a way that shows some respect and for the dignity of the citizens that the police are dealing with. But I'm wondering whether these are two completely different areas that might require, perhaps even different types of commissions to deal with.
Well, they are different. I do think that the same commission can deal with both. I mean, look at the issue in terms of, for example, the debate about whether quotas exist or don't exist.
What?
Quotas. If quotas exist, that plainly is going to create pressure which will affect the interface between the officers and the community as they're, working to, quote-unquote, meet their non-quota quotas. So, I think, an entity that could look at that issue as an example could be useful. Even on, an entity that could look at, some of the stop and frisk policies. In other words, I don't believe that, you have the Civilian Complaint Review Board that is going to look at an individual incident. And the issue is whether, and the review board does have some authority to look at sort of some policies. But I think, the existing commission, with a little more authority and this responsibility also can look at some of the core issues and policies that may be generating some of these questions.
Willie?
Yeah, Willie Rashbaum from the Times. On a scale of 1 to 10, given your experience collectively, how would you rate the overall oversight of the police department from CCRB to the City Council to the current commission? And do you think that the department's lack or the department's failure to keep track of various of these issues, excuse me, the 1983 cases, as you point out, rulings in suppression hearings, that sort of thing, do you think that that interferes with effective oversight?
Rich may be a little closer to this. I just sit on this bench and watch it all happen. It's been a long time since I was in and close enough to the police department to understand what it was doing. And what happened, or what appears to be happening from what I do see, which isn't, which really is much less, I'm sure, than Rich, is that there's and I guess we talked about this. I think this blue line by which each cop protects himself from others, and they band together to make a fairly significant roadblock in terms of any law enforcement activity that might be appropriate. From what I can see sitting on the bench, which, as I say, is minimal in this area, is that has not gone away. And that it was one of the things that we had hoped in the Mollen Commission 15 or 20 years ago, we would somehow be able to stem. But it just comes back and seems to me to be there today, to a greater or lesser extent. Rich knows more.
Well, I don't know if I know more, but, and I'm not sure what 1 means and what 10 means in this context. But I think without using a number, I think if you just look at, sort of the public record and some of the council hearings that have taken place, I would say it would be, I think, in the public's interest and the department's interest if there was more oversight and more effective oversight than there is today.
This is the last question.
Right. It's actually not a question. Rich, I don't know if you know that or not, but in 1993, in fact, Commissioner Kelly did agree for a computer system to assimilate all of the data that came in through 1983 and provide it to IEB. What happened to that, it was something, I don't know whether your organization ever looked into that, but that was actually something that the Commissioner did agree to in between the 93 to 95 period, because it was the advice of IEB at the time to do that.
Could you just identify yourself?
Yeah, I'm Walter Mack. I actually was the Internal Affairs Bureau Deputy Commissioner in 93 to 95.
Thank you. Okay. This has been very stimulating on a topic that is coming back. The question I would ask, do we need another commission? Yes or no?
Another special commission?
Yes. Do we need another special commission? Yes or no?
No. I think we need more effective ongoing oversight.
Yeah, I would share that view.
Okay. Okay. As we always do before I do that, stay here, please stay. I just want to introduce Anthony Crowell, who is going to be the new dean of New York Law School, and he is For the last 9 years, he's been the counsel to Mayor Bloomberg. We're delighted that he's coming here to be our dean. We think that we'll be easier than Mayor Bloomberg to deal with. But he's survived that, and we're delighted he's going to be the dean. As we always do, though, we like to give product of the scholarship of New York Law School, and so this is a real scholarship. Two symposiums on criminal law, civil liberties 10 years after 9/11, and exonerating the innocent, pretrial innocent procedures. And we give it to both of you, knowing that you will read every word and that it'll be useful to you. Thank you all for a very stimulating day. We'll see you on April 20th. Yeah, sure. We're